Good evening and welcome everyone to the lecture series of CLAT Preparation 2023. In this particular lecture series, we are talking about legal reasoning, one of the most essential parts of your CLAT syllabus. In the particular lecture series, we have earlier talked about the different provisions of the Contract Act. We have started with the criminal law, and in the previous lecture, we were talking about the different definitions of the offences that has been mentioned under the Indian Penal Code. We have discussed about culpable homicide and murder. What is the difference between culpable homicide and what exactly is a murder? We have talked about kidnapping. We have talked about abduction. We have talked about theft. We have talked about extortion. We have talked about robbery and dacoity. And there are other offences also which are of relevance for your CLAT preparation. We have discussed those. Now we are continuing with the remaining of the sections that are there. In that particularly, we are talking about offences where which misappropriation of property is being considered as an offence. When we talk about misappropriation, as the word suggests, misappropriation means taking wrongfully for own use any property. So the main crux of this particular offense is that if somebody takes out of the from the possession of the owner, or maybe if there are joint owners without the permission of the other owner, and use that property for the benefit and for the profit of his own, then the person has committed an offense of dishonest misappropriation of property. Here we need to understand what are the essentials of dishonest misappropriation so that we can be able to answer the questions which is in relation to dishonest misappropriation of property in our CLAT examination. The first and the foremost thing that we need to understand is when we talk about dishonest misappropriation, it is understood that the property should be of someone else. If the property is of someone else, then obviously it is clear that the property can be misappropriated for the own use. Second important feature being that the property should be movable property. As we have discussed in our definitions of theft, that it is not possible to get any property which is immovable to be under the definitions or the essentials of theft. In the same way, in order to consider that there is an dishonest misappropriation of property, we need to understand that the property should be movable also. Let's try to understand what exactly the definition of dishonest misappropriation of property according to Indian Penal Code 1860 suggests, and then we will try to understand it by use of illustration and explanation that will be provided by me, so that you may be able to understand what exactly is dishonest misappropriation of property. So the definition, as it has been highlighted over the screen, says that dishonest misappropriation of property means whoever dishonestly misappropriates means taking wrongfully for own use or benefits, or converts to his own use any property, any movable property, shall be punished with the imprisonment of either description for a term which may extend to 2 years or fine or both. So the punishment here for dishonest misappropriation of property, DMA, is maximum of 2 years or will be fine or both. So you will find mention of these type of offenses where which the person is having authority or access to that particular property, but that particular property was never being used or never been confined to that particular usage itself. Rather, that property is being misappropriated for the benefit of the offender. So we will try to understand that particular things through the examples that we have in front of us. And then we will try to summarize that what exactly is dishonest misappropriation of property. The first illustration says that A takes property belonging to Z out of Z's possession. Okay. So A is the person who is being considered as an offender here. Z property from Z's possession in good faith, believing at the time when he takes it that the property belongs to himself. Okay, so there is an illustration where which I have a pen. I strongly believe that it is my pen, and in good faith I took that pen and from a particular place. Let's assume maybe a library. I was sitting there. I was under this impression that this is my pen. I utilized those pen. I took that pen and moved away. And then after a certain period of time, I came to know that this property was not actually my property. This pen was not my pen, but rather of somebody's other pen. So at that point of time, since as we remember the essentials of theft, that there should be dishonestly movable property being moved out from the possession of the owner. What we see that since it was not done intentionally or dishonestly, it will not be considered, I shall not be guilty of committing theft. But once I come to know, it is my duty to return the pen to the rightful owner so that he may utilize his property, and I will not be held liable for any of the crimes that might have been committed. But instead what I do, I use that property for my benefit. I told somebody that this is a very beautiful pen. I sold it for maybe rupees 500 or 600. At that point of time, I have committed an offense. And that offense is not only restricted to committing theft, because yes, the essentials of the theft has been committed. So yes, we can say that the theft has been committed. But apart from theft, I have committed one more offense, and that is dishonest misappropriation of property. So you need to understand that whenever there is theft happening, somebody commits theft, there are high chances, high probability that particular person is going to misappropriate the property for its own use also. This particularly happens when the person have good faith. He has the knowledge that property partially belongs to him, or he has the right to use that property. But once he comes to the knowledge that property is of somebody else, and even after that knowledge, that person uses that property for its own use or a record, then he has committed the offense as mentioned under section 403, that is dishonest misappropriation of property. So here what we see is that there is a breach of trust. Whenever we have access to somebody's properties, and obviously it is believed that the person to whom the access has been given will not misappropriate the property, and if that particular person misappropriate the property for his own use, okay, then it is considered to be an offense. I'll give you one more example so that it is better. It will be better understood by you. Let's take an example that there are two friends. One has a good collection of novels, and the other person also likes to read novels. He goes to the house of A. Let's take the example that the person who is bearing the good amount of novels is A, and B also is fond of reading the novels. He goes to A's house and thinking that this particular novel, let's take the example of Wizards of Oz, is his property. Thinking that particular property to be his own, he takes that property from A's possession, and he then, after reading it, he understands that okay, this is not my property, this is not my novel, but rather it is A's novel. But instead of asking him before giving it to somebody else or taking advantage of that book by selling it or by getting it copied or by any of the sources whatsoever without the permission of the other person, it specifically means that what I am doing is something which is dishonest, something which is for my own benefit and with the property of somebody else. When all these three requisites are there, it specifically means that we are dishonestly misappropriating the property that does not belongs to us. Initially, dishonest misappropriation of property will give you a hint when you will be solving the question that property, initially the person was of a good faith, that the person strongly believed that the property belongs to him, or he has good reasons to believe that the property can be used by him. But after a certain period of time, he comes to know that this property doesn't belong to him, but rather he doesn't have the permission to use that property, but still he used that property for its own benefit. Then he has committed the offense of dishonest misappropriation of property. Taking this particular example B, which says, the book for the purpose of reading it. You must have seen that whenever we are with friends, we seldom ask them their permission to take their items, but because it is obviously understood, it is implied that we have the consent to use our friends' books, our friends' property. But if that consent is still under our pretext that we have the consent, so we have not committed any sort of theft. That is clear, because we have just recalled that the essentials of the theft specifically says that there is a dishonest moving of property without the consent of the owner, out of the possession of the owner. But here, if we have the implied consent, okay, I can use your property, but after coming to the knowledge that I do have the property of that doesn't belongs to me, I only have the possession of the property and not the ownership. I use that property in such a manner that it's going to benefit me without sharing the benefit with the owner of that property. We have committed dishonest misappropriation of property. So here, after for the purpose of reading it, so here until this particular point, there is no theft. There is no offense that has been committed. It is perfectly legal to do this particular act. But if A afterwards sells the book for his own benefit, I have read the book, now I feel that there is no point of keeping it, I sold the book to some other person, I have committed an offense that is guilty under this particular section, that is dishonest misappropriation of property. I suppose it is clear to you. You can read the other examples also for your better understanding. There is one explanation that we need to understand, that if there is a property which is out of possession of owner, and when owner is not known, then what? So this particular explanation too suggests that a person who finds property not in the possession of any other person, okay, not in the possession of any other person, and takes such property for the purpose of protecting it or for restoring it to the owner, does not take or misappropriate it dishonestly and is not guilty of offense. But he is guilty of the offense above defined as if he appropriates to its own use when he knows or has the means to discover the owner, or before he has used reasonable means to discover it and give notice to the owner, and has kept the property in reasonable time to enable the owner to claim it. What are reasonable is for question of fact, this is not important for you. This particular point is very much important. Yes, it is not necessary that the finder should know who the owner is of the property, or that any particular person is the owner of the property. It is sufficient if at the time of approaching it, he does not believe it to be his own property, or in good faith believe that the real owner cannot be found. So if these two things are there, if he knows that the property doesn't belong to it, not my property, And the second thing is real owner cannot be found. This particular example is of lost and found goods. You were on the highway, you saw a bag full of cash. You when you took that bag, you tried to find out who the owner is. You provided reasonable information, but in the end of the day, you were not able to get the correct information that who exactly is the owner. You even went to the local police stations to find out who the owner is, but eventually you were not able to get that particular information also. So even if that property belongs to somebody else and you are pretty much sure that the owner cannot be found, in good faith, after trying each and everything, and after a certain period of time, you use that property, you have not committed any offense. And this is what the beauty is of the law, that if somebody has not done anything dishonestly and that work has been done honestly, you will never be considered guilty of any of the offense. But the main crux is that there shouldn't be any dishonest or illegal approach in whatever acts you are doing. So it specifically clearly shows us that this illustration will also help you in understanding in a better way that A finds a rupee on a high road. So because since it has been mentioned in 1860, so you can understand that 1 rupees will be equivalent to around maybe say 10,000 rupees today. So A finds a rupee on a high road, not knowing to whom the rupee belongs. A picks up the rupee. Here A has not committed the offense defined in this section. Okay. So there is no offense of criminal dishonest misappropriation of property. A finds a letter on the road containing a banknote. From the direction and contents of the letter, he learns to whom the note belongs. He appropriates the note. He is guilty of the section. But once we know that who the owner is and still we misappropriates the property, then it is considered to be criminal misappropriation of property. I suppose this is pretty much clear what exactly is dishonest misappropriation of property. You can go through these sections, illustrations, it will be easier for you to understand. This illustration is perhaps important. A finds a purse with money, not knowing to whom it belongs. He afterward discovers that it belongs to Z and appropriates it to his own use. A is guilty of an offense under this section. Even after a certain period of time, if you come to know that this particular property belongs to Z or any other person XYZ, then if you appropriate it to your own use, then you will be guilty of this section. But after a reasonable time period has elapsed, and what exactly will the reasonable time period will depend upon the facts and circumstances of the case. We cannot provide you a detailed summary that or maybe a timeline as to this particular, after this particular timeline you can use that particular thing for your own record. It depends upon the property also. Suppose that the things that you received on the highway or you found on the highway was not any cash or any check, but rather it was any perishable good. Like take example, pack full of apples, a packet full of apples, and that is perishable in nature. You tried to find out who the actual owner is, but you were not able to find out. And after a certain period of time, when you saw that it is going to perish, what you did, you sold it so that at least revenue can be taken place. So at that point of time, you haven't done any offense. Until unless you are pretty much sure that the owner is not, we cannot find the owner, and that is the property. The property is also going to be perished. So it's better, and it is a good approach. And since you have sold that property, it will not be considered as an offense. A finds a valuable ring, not knowing to whom it belongs. A sells it immediately without attempting to discover the owner. A is guilty of an offense under this section. Now, if he is selling the ring, then also it is considered to be an offense. So what we need to understand is that it is very much important for not being involved under dishonest misappropriation of property is that if you have knowledge that this property, not my property, you know the owner, takes property from the owner's possession, whether in good faith or bad, because if in good faith, there will be no theft. If bad faith, then it will be theft also. And after that, misappropriates the property. He shall be liable under section 403 of IPC. Is it clear? Yes. Now let's move forward and let's see this particular example. This is also very important. I suppose dishonest misappropriation of property is pretty much clear to you all, because dishonest misappropriation of property is also a very important topic. You will get questions on this particular topic also. Now there is another offense, which is known as criminal breach of trust. In both the offenses, section 403 and 405, we find mention of trust, because in the earlier instance when there was criminal misappropriation of property or dishonest misappropriation of property, DNP, then there was a trust by the owner. That is perhaps the reason there was an implied consent. That even after taking the possession, even after securing item or property from the possession of owner, no offense was committed. But the moment you break that particular trust of the owner by misappropriating for its own use, then it is considered to be an offense. When we talk about criminal breach of trust, initially, as we have understood when we were studying about the difference between theft and extortion, and when we were studying about robbery as theft and robbery as extortion, we got to know that when we talk about criminal misappropriation of property, it is something that we by ourselves will do when we want a property and we want to appropriate for its own use. But when we talk about criminal breach of trust, it is something when the property is entrusted to us by the owner, by himself. For example, my neighbor were going for a road trip, so they felt that it is necessary for them to send their dog to me to make sure that I care for that dog. Once they were gone, what I did was I took that dog and I sold it to one of my friend. And when he came, after that, when they came, when they asked me that where exactly is the dog, I told them that I have sold it to my friend. So this is something, because it is considered as criminal breach of trust. So trust, whenever you are breaking the trust that has been entrusted to you, then you are liable under this particular offense of criminal breach of trust, that is 405. Whoever being in any manner entrusted with the property, this is first requisite, or with any other dominion over the property, dishonestly misappropriates or converts to his own use that property, or dishonestly uses or disposes of that property in violation of any direction of the law prescribing the mode in which such trust is to be discharged, or any legal contract express or implied which he may have touching the discharge of such trust, or willfully suffers any other person to do so, commits criminal breach of trust. So this is important for you to understand And for that, you need to go through the illustrations also. Illustrations will help you in understanding that what exactly can be a situation where which a person can be considered as an offender for criminal breach of trust. The punishment for the same is maximum 3 years or with fine or both. Now you must have seen a difference under section 403 and 405, that under there the punishment is 2 years maximum and with fine or both, and here it is 3 years. So the main difference, the major reason behind increasing the punishment for criminal breach of trust is because the owner had by himself entrusted the property in you, meaning which they have the trust with you, and you have broken that trust by dishonestly misappropriating the property for your own use. And that is why criminal breach of trust has been given much more hard punishment, or if I may say a greater punishment in comparison to the criminal breach of dishonest misappropriation of property. So these are the important sections in regards to the property which you may be asked in your CLAT examination, and that is why it's important for everyone to at least understand what are the different sections are saying. And then you also have to study cheating. If you can just go through the sections, you will be able to understand what exactly cheating is. And now we are going to read the most important provision of the IPC, Indian Penal Code, and which is talking about defamation. Defamation is very important because you might get questions in regards to defamation directly by you. We will be provided a principle where which the definition of defamation will be written, and then there will be a factual questions that will be put in front of you, and you have to answer those questions accordingly. So first and foremost, we need to understand what defamation is and how is it important for your CLAT examination. We need to understand the requisites that will be helpful in understanding that this particular act will be considered as defamation or not, whether indirect statements can be considered as defamation, whether actions which may be made can be considered as defamation. All these questions will be answered by understanding the definition of defamation as mentioned in section 499 and also visible in front of you over the screen. If we can read this particular point of section 499, which talks about the definition of defamation, says that whoever by words either spoken or intended to be read. So the first thing is it can be spoken also. So how defamation can be done? By spoken words. Second being read. Third being signs. And fourth being visible representation. Okay, visible representation. Visible representation means again, the best example can be cartoons. You must have seen graffitis in your newspaper, or where which you have seen different politicians. There is a concept which is being described through that particular drawing, and this sometimes goes to that extent that the person against who has been mocked or who has been taken into account in that particular drawing sometimes feel that the information which is being provided through that drawing and the message that particular drawing is being conveying is going to harm the reputation of me. And that is at that point of time, the person is considered, the person who has created the drawing is considered to have defamed the person. Makes or visible representation makes or publishes any imputations concerning any person intending. There should be intention. Okay, this is very important. Intending to harm or knowing. The first thing is this is how, and this is why. The first is intending to harm. There should be intention. Second being knowledge. Third is reasons to believe. So there is knowledge, either it can be intention or it can be knowledge or reasons to believe that such imputations or remarks, if you may say, will harm the reputation of such person is said, just remove this exception, to defame that person. So if I make visible representation, if I write something, if I speak something, knowing to this fact, or if I make visible representation, knowing that fact with the intention or with the knowledge that this particular imputation is going to harm the reputation of the person, is said to have defamed the person. But these defamations have certain exceptions that also needs to be addressed, because once the questions will be there, it will not be directly asked that, okay, whether this particular act has to be considered as defamation or not. But there are chances that you might get the questions directly also, but it is obviously recommended that we go through the exceptions also, so that once we get those questions in our question paper, we are actually acquainted with the explanations and the exceptions that will come in handy while tackling the questions that will be put in front of you in the question paper. The first explanation says that it may amount to defamation to impute anything to a deceased person if the imputation would harm the reputation of that person if living, and it's intended to be hurtful to the feeling or other relatives. So even a deceased person can be defamed. Deceased person can also be defamed. This is important requisite. You need to remember this, that here in the definition, it is not necessary that the human, the majority of the time it is the human being against whom the offense has been done, that particularly is going to be the victim whenever these offenses are made. But when we talk about defamation, it can be for the deceased person also. That is why we need to understand that what are the important requisites, and that is why explanation comes in handy. So first explanation talks about deceased person, that even a deceased person can be defamed. The second explanation says that it may amount to defamation to make an imputation concerning a company. It means a company can also be defamed. An imputation in form of an alternative or expressed ironically may amount to defamation. Okay, so there is a alternative or expressed ironically may amount to defamation. So if I say that Rahul is a very honest man, he seldom steals. So this type of remark, this type of derogatory or alternative remark, which we want to convey through our statements that Rahul is not actually honest, but rather he is dishonest, and he seldom steals, means that there are high chances that he might have stolen the item or product. Then this type of communication, which is not being done directly but rather indirectly, is considered to be a defamation also. No imputation is said to harm a person's reputation unless that imputation directly or indirectly, in the estimation of others, lower the moral or intellectual character of that person, or lowers the character of that person in respect of his caste or his calling, lower the credits of his person, or cause to be believed that the body of that person is of loathsome state, or is generally considered to be disgraceful. Once we need to understand is that, okay, this is done, that how it has to be there. Now there is one question. There is two people in the house or in a room. A says something about B to B and B says something about B to A. Can it be considered as defamation? The answer is no. The reason being, if we see and we read in the particular second line, we see that makes or publish. And this particularly makes and publishes can only be possible when it is being done in front of other persons. If there is no person present and there is only one person present, we cannot say that the person has defamed anybody. It should be in public. Once the public has come to know, or any other person comes to know apart from the person who has been the accused and the victim, then defamation has said to occur. Let's try to understand the illustrations so that it becomes easier for us to understand. The first and the foremost is, A said, I just gave you an example, Z is an honest person, he never stole B's watch, intending to cause it to be believed that Z did steal B's watch. This is defamation unless it falls within one of the exceptions. Now it is clear to you that what exactly is defamation. Let's try to understand what are the exceptions. The first and the foremost exception of defamation is imputation of truth. If we are saying something which is true, then it will not be considered as defamation. Second is public conduct of public servants. If there is any act which is being conducted by public servant in public, it will never be considered as defamation. It is not defamation to express in good faith any opinion whatever respecting the conduct of a public servant in discharge of his public functions or respecting his character. And that is perhaps the reason you might have seen the news channels and different broadcast networks who always criticize the conduct of the politicians or the administrators, that is the bureaucrats on the news channel, and still they have not been considered as it is not considered to be defamation, because what we are doing is we are actually providing an opinion or faith, in good faith, what exactly is the public conduct of that particular public servant. So that is also under the exception that nobody can be held liable for defamation if they are providing a review or a feedback about the public conduct of that particular public servant. The third exception being conduct of any person touching any public questions. So there is a person who has see this one. It is not defamation in A to express in good faith any opinion whatever respecting Z's conduct in petitioning government on a public question, in signing a requisition for a meeting on public question, in presiding or attending to such meeting, in forming or joining any society which involves the public support, in voting or canvassing for a particular candidate or for any situation in the efficient discharge of the duties of which the public is interested. So if we are questioning to what extent the government has worked and to what extent that particular person has worked for the benefit of the citizens, then it cannot be considered as defamation. That is something that we need to understand. Then court proceedings. If there are court proceedings which there will be mentioning of different accusations against the person, and now after a certain period of time, the person who has been considered as the accused, and let's take example, the person who has been considered as accused is released because there were no sufficient charges that were supported by the evidences. He cannot come to the court and now claim that I have been defamed by the court and I want actions to be taken, because that is publications of reports of the proceedings of the courts, and that is why it cannot be considered as a defamation. The fifth one is merits of the case decided in courts and conduct of witnesses and other concern. So if the conduct, the witness whomsoever will be provided, A says, I think Z's evidence on the trial is so contradictory that he must be stupid or dishonest. A is within the exception if he says that in good faith, inasmuch as the opinion which he expresses respects Z's character as it appears in Z's conduct as a witness and no further. Okay, so it is clear that the when the witness is being corroborated during the investigation, during the court proceedings, then whatsoever has been said by the advocates is within this particular exception, and he will not be convicted or accused of defaming the witnesses. The sixth being merits of public performance. As we have said, that it is not defamation to express in good faith any opinion respecting the merits of any performance which its author has submitted to the judgment of the public. So there are publications, there are YouTube channels, I suppose you have seen, where which people have given their contents and their informations, and they have asked the opinion of the public. And when the public starts giving an opinion, they cannot go to the court and start saying that this particular person has said ill things about me, and this particular person should be there should be a case registered against him for defamation. That is not possible. You can go through the illustrations also. The illustrations will help you out in understanding much more clearer aspect. A person who publishes a book submits the book for the judgment of the public. Now this is not defamation, because he voluntarily provides his consent for this feedback. Then censure passed in good faith by persons having lawful authority over another. It is not defamation in a person having over another authority, either conferred by law or arising out of lawful contract made with each other, to pass in good faith any censure on the conduct of that other in matter to which such lawful authority relates. You can read this particular section for your better understanding. And then these last three examples are exceptions. This perhaps is not actually important for you. You can just go through it, just read it so that you can get an idea that what exactly is the scenario. Imputation made in good faith by a person for protection of his or others' interest. Okay, so this is manager shall sell nothing to Z unless he pays, because for I have no opinion of his honesty. So this is something which cannot be considered as defamation. So I suppose you have now a clear understanding that what are the different offences that is related to Indian Penal Code. We have covered majority of the sections that will be that are supposed to be asked, or that will be asked in your CLAT examination. You are expected, as I've already informed, that you are expected to make sure that you are actually studying each and every sections in a detailed manner. And once you have understood the sections, and once you have understood the difference between the different sections that has been mentioned, then it will be very much easier for you to correlate with the facts that will be provided to you in the examinations. And based on this illustrations and the principles and the concepts, you will be able to answer the questions that will be there. With this, we have completed our another topic of Indian Penal Code. So far, we have completed Indian Contract Act. Indian Contract Act has been completed. There is one lecture for the case law which will be taken into account in the last sessions of this series. Rest you can start tackling questions which is in relation to Indian Contract Act through the previous year question papers. You can use the PYQs to start solving the questions. And also for IPC, Indian Penal Code is also completed. You need to just revise these sections, and then after a certain period of time, you should start practicing the PYQs for IPC also. With this, I suppose everything in regards to the Indian Penal Code has been completed. Since I was going through the syllabus, I came to know that the questions in relations to Code of Criminal Procedures and Indian Evidence Act has been evaded or removed from the syllabus. So we will not be going forward, and we'll be tackling that. Now, we will be starting with another lecture series that will be in regards to the Constitution of India. Constitution of India. In the Constitution of India, if I give you a summarized lecture, that what are the things that we need to study, the first and the foremost thing that we need to study is the preamble of the Constitution. It is very important for all the CLAT aspirants to understand what the preamble of the Constitution says. What exactly is the Constitution? Why is it so important? And it is considered to be the grundam, the main source of all the laws from which the laws has been derived. So we need to understand what the preamble is. We need to understand what is the definition of a state, how the state is formulated, and whether the state is according to the Constitution, what exactly state means under Article 13 is very important. But if we will be only tackling it for our CLAT perspective, we will be talking about fundamental rights. We will be talking about directive principles of state policy. We will be talking about fundamental duties. We will be talking about the courts, structure of the courts, court structure. Apart from that, we will be talking about emergency provisions, very important for your examinations. We will be talking about amendments, and we will be talking about the writs of the courts. So specifically, if we talk about all these points, 1, 2, 3, 4, 5, 6, 7. Apart from that, is there anything else left in Constitution? Yes. The sources. Sources are something that you will not be getting the questions on your paper directly, but there will be a fact that will be there, Constitution, and then it will be related to some of the concepts that has been derived from the Constitution, from the other constitutions. For example, rule of law. Rule of law is something that has been derived from the United States of America. So if we talk about the rule of law, it's actually United Kingdom, United States of America. There are different things that we have derived from United States of America, but the rule of law has been derived from Great Britain. So what exactly is the rule of law? First thing, and why is it important? So the factual questions will be in relations to something which is known as rule of law, and then there will be a one question that will be put in front of you, and that will be asked that from which country India has taken the provisions of the rule of law, and there will be 4 options: India, France, Germany, England, and US, and you'll have to mark the right answer. So for that, we need to understand all these important provisions, and we will be starting with our lecture on constitutions from the next video onwards. So I would request all of you to kindly start practicing the Indian Contract Act and the Indian Penal Code, since it has been completed. And once you'll start practicing, you'll come to the knowledge and understanding that how you have to deal with the questions that will be put in front of you in regards to Indian Contract Act and Indian Penal Code. We expect that we will complete the lecture series in regards to the Constitution of India within 5 to 6 lectures, and post that we will be moving forward with another important yet very interesting subject, and that is your law of torts. Once we have completed with the law of torts, we will be moving forward with intellectual property rights, that is IPR. It is a small but yet interesting yet important topic, and that post that we will be completing with your international law. In international law, we will be talking about the various organizations that are there. Apart from that, we will be talking about United Nations Charter and the organs of United Nations. We will be talking about IMF, International Monetary Fund. We will be talking about WHO and other agencies which are of relevance for your examinations. So with this, I conclude today's video. Let's meet tomorrow with a fresh mind, which we will be starting the most important and the most interesting topic or the subject for your CLAT examination, that is Constitution of India. It is something which I would recommend. It is not only confined towards the preparation, but every citizen who is by birth the citizen of India or is residing in India should actually know what their rights are, what their obligations are. And that is why it becomes very important for every person whomsoever is watching this video to have a thorough knowledge and understanding of what the Constitution is and how the Constitution is providing the whole framework or the main source for all these existing legislations, all the formation of the government, and how it is making sure that the structure of the government, the structure of India is not getting affected at all. With this, I would conclude tomorrow's videos. Thank you so much for your patience hearing. I will be meeting you in the next video. Till then, bye-bye. Take care.